Hi, my name is Joshua Houston. I'm General Counsel to Texas Impact. Health insurance is a vital part of people having access to health care and so that their families do not face financial ruin when a loved one falls ill. That's why we have long been supportive of the consumer protections in Senate Bill 1795. Consumer protections are vital in order for people to have confidence that they will be protected from malfeasance when they go to sign up for health insurance. Because those consumer protections are so important for people obtaining coverage, we want to see any rule that should be adopted to remain in effect to protect the consumer. We are concerned that the rule as it is currently proposed could suffer both potentially from substantive and constitutional challenges as to its validity. We greatly hope, let me emphasize that we greatly hope that this can be avoided. A challenge to the rule not only puts many important consumer protections at risk, but also leads to increased publicity, consumer confusion, and an overall decrease in consumer confidence, which may lead to fewer people obtaining the health coverage that they need. The most serious legal claim we think against the rule comes from the definition, the applicability, and the required registration sections, which are 19.4002 through 004. The effect, is to redefine the term navigator as an activity as opposed to a designation. In other words, to use a metaphor, the proposed rule is like saying anyone who swims with scuba gear, lands on a beach, and carries a firearm is a Navy SEAL. We believe that this is kind of a fundamental misunderstanding that is putting the entire rule in jeopardy. As I'm sure you are aware, an agency's authority is a question of law determined through statutory construction. One basic rule of statutory construction is that when the legislature has provided a definition for a word in a statute, then the court will use that definition. Senate Bill 1795 clearly defines that the term navigator. It is those that are described under 42 U.S.C. 18031, which defines a navigator as a federal grant recipient that must perform certain duties. It is a very narrow definition. Any redefinition of navigator risks the rule no longer being in harmony with the general objectives of the statute. There is a scope of practice case from 2008 called Texas Orthopedic Association versus the Texas State Board of Podiatric Medical Examiners. The state board in that case impermissibly expanded the definition of the word foot. In this case, the Austin Court of Appeals found that the board had exceeded its authority by too broadly defining the word foot to involve parts of what we would commonly call the ankle and invalidated the entire rule. Additionally, the proposed rule casts a very wide net. The definition of what constitutes a navigator service includes the use of the conjunction or, which connects the definitional elements of possible services that one could perform in order to perform navigation services. That means that providing linguistically appropriate information or establishing standards for data security make one providing a navigator service rather than requiring an entity do both. Not only is this overbroad, but we feel it is also vague. It fails to provide fair notice to a person subject to the rule and makes difficult guidance for those tasked with enforcing it. For instance, in a recently high-profile case, not to pick on them, but Target had a data security issue. Presumably, they are fixing this data security problem, establishing new standards. A corporation of that size also probably has an HR department. If an HR department were to assist employees with enrollment, then under this proposed rule, they would have to register as a navigator. An additional example is if an entity were to provide enrollment services in Spanish, in other words, providing linguistically appropriate information, that could arguably subject that entity to the registration requirements should they do enrollment assistance. Third, the application section we believe is also vague. It is not clear who is exactly exempted under 19.4003C. To kind of walk through that provision, it is not clear what level of regulation that an entity would be under that would constitute state and federal authority. For example, both for-profits and non-profits are governed by the Texas Business and Organization Code and are regulated by the Secretary of State, the Comptroller, the Office of Attorney General. That's just to name a few. it is not clear if that would be enough authority or not in order to invoke their coverage. If it were enough authority, then the next section that is also vague is exactly what does it mean in that last clause to the extent that the entity is providing assistance consistent with that authority. It is unclear what level of inconsistency would then invoke the department's jurisdiction. Fortunately, we think that there's a simple fix. Simply maintaining the definition of navigator that the legislature explicitly put into statute would fix all these problems. Sticking to the statutory definition significantly confines the world of possible plaintiffs as well, whereas standing in an overbreadth challenge to a rule is exceptionally broad to just about any outside group. Restricting the definition of navigator to the statutory definition will significantly narrow the world of people who could possibly bring an action. Additionally, it reduces the possible causes of action against the rule and takes away what we think is the most serious, which is the definition. Other claims may still exist. For instance, in other states that have passed a similar rule, conflict preemption was raised with regard to the state prohibitions on advising a consumer to a plan, whereas the federal law requires a navigator to facilitate selection of a plan. So the issue comes down to what is the difference between advising and facilitating. One suggestion that I have that would be better for both going down the road and for those being regulated is to put an explanation of what that difference is in the reason justification for the rule. Another possible preemption claim that has come up elsewhere involves a doctrine called impeding the achievement of a federal objective. There's not a bright line rule for this. These cases are usually extremely fact specific, but one suggestion that I have that could help avoid this kind of challenge would be to push back the effective date. March is the last month for compliance with the individual mandate. It is kind of human nature to often wait until the last minute to do a thing. There are substantial training requirements which make up the equivalent of an average person's work week that would be going into effect at exactly the same time most of the people are going to try to get coverage to comply with the individual mandate. Pushing it back just 1 month to April would probably be viewed very favorably by a court. And lastly, navigators are funded using federal tax dollars. The general rule is that it is impermissible to put a state tax on a federal activity. However, there are many exceptions. The difficulty in this lies in determining just how far removed the taxed entity is from the federal activity. Pragmatically, though, the more the fee could be limited, the less anybody will probably care. We're going to be filing more detailed written comments later today. I appreciate the opportunity to be here today. Thank you for holding this second hearing. I know it was extremely helpful for me personally, given the holidays, and I'd like to just thank the staff for all the hard work that has gone into this rule. It's been, I'm sure, very time-consuming, and it's been a pleasure to work with you, and I look forward to working with you in the future. Thank you.